there we go. I think we're good. Okay, so I think the first question I had is sort of a general one. I mean, I know that this county has had crowded fields before, but this seems like one of the more crowded. I mean, 5 candidates for this one seat. How do you distinguish yourself from the pack, I guess, would be the way I'd ask that.
The thing that makes me unique is that I already work for the court. I serve as a pro tem judge on average 60 days per year already. So it's simply my experience sitting on the bench, and I've actually done that for 13 years. And again, so it's just my varied aspects. I've worked in civil, probate, family law, family support, juvenile delinquency, juvenile dependency, traffic, small claims. I'm certified in all of those areas as a pro tem judge, a temporary judge. And so it's simply my experience that I've already been attempting to do that job or have a lot of experience sitting there being a temporary judge.
And you just started to explain that, and I kind of wanted you to expand. I don't know how many people know what a pro tem judge is and how that works, and what kind of cases have you sat on?
Okay. The California Rules of Court have specific guidelines for certain areas of law to be a temporary judge. You need to be an attorney for at least 10 years. And in addition, you have to have specialized training in judicial ethics, judicial demeanor, and substantive law training. So you get certified, you take certain certifications, and then it gets signed off by the presiding judge or the CEO of the court to allow you to serve as a temporary judge. And it also requires the litigants to agree to allow you to do it, because their constitutional rights permit their matter to be heard by a real full-time judge. But if you're certified to be a pro tem, you can sit on the bench, but the parties have to agree to allow you to be a judge for the day. And I have received the certifications in all the areas in which certifications can be made, which is the same list I gave you: juvenile delinquency, dependency, family law, family support, probate, small claims, and traffic. I think I got them all.
Okay. One of the questions, and I asked this, at the League of Women Voters Forum, but I think it's such a complex issue, and I think even though I've written about it, and Judge Dowling, wrote about what happens with defendants who kind of come in and out of court and who are bailing out at fairly low bail amounts, how whose role is that to monitor and maybe prevent that revolving door? I was wondering if you could speak to that.
Well, the revolving door primarily deals with misdemeanor defendants. It can happen with felony defendants, but I see it mostly with misdemeanor defendants. There's a law that provides that an individual that is arrested for a misdemeanor is presumptively entitled to be released without bail. And that's what the law presumes. And so there has to be a showing to set bail at a reasonable amount in order to set it at all. In addition, we have bail schedules that are pretty much in line with all the other counties. Our bail schedule is available on the court's website. They're looked at every year to see if it's appropriate or different areas need to be changed. Again, our bail schedules pretty much mirror everybody else's, all the surrounding counties.
Which, and I haven't examined this, so you'll have to forgive me for making this comment, but I have been told, by law enforcement, of course they have their own bias, that, for example, ours is not, does not compare to Placer, for example.
I have not compared them side by side. I've done a quick look at the most common bailable offenses, and I saw that they were pretty much in line. I would be happy to take a look at them. And if that issue is brought up to the judges review that bail schedule every single year. So if there are concerns, members of the public that are affected by this, especially law enforcement, the DA, the public defender, if they were to bring their concerns up to the judges, that would be taken into consideration to either raise or lower accordingly. As for the bail schedules themselves, the judge cannot on his own motion simply raise bail. there has to be a request to enhance that bail, and that needs to be done by the prosecutor. Or there needs to be a request for a probable cause hearing within 48 hours to see if we should continue to keep this individual in jail. Mm-hmm. So again, a judge's job is to simply apply the law. A judge can't simply go, I think we're going to convert this to a felony today. And so, unfortunately, the burden is on the prosecution, who enforces the laws, who's part of the executive branch, in order to make those requests. And then the judge's job is then to determine whether that is a reasonable request.
Okay. To also, I hope, some of these questions are bouncing around quite a bit, and I hope you're okay with that. And it's just, there's probably some different ground that I want to cover, but one of the things that I wanted to talk about was how realignment is affecting sentencing. I mean, it's been in place for about 2 years now?
Yes, it was back in 2011, the United States Supreme Court ruled that the overcrowding issues in California prisons violated the United States Constitution.
Right.
And so we've had to do realignment. Basically, that means individuals that are in the state prisons have been either released or sent to the county jails. Mm-hmm. And then due to the squeeze factor, the county jail individuals have either been released or alternative programs or probation or parole. Mm-hmm. It's a significant issue. Mm-hmm. I'm a mother of 4 kids. I don't like the idea of letting individuals that have been properly convicted simply go free because the prisons are full. So I have concerns with that, but that is what has been ordered by the United States Supreme Court. Mm-hmm. Now, Governor Brown signed a lease with 3 private prisons in Southern California that opened up more beds, and I think that's an excellent idea. Let's get more beds, because that was the problem. Back in 2011, we had the capacity to house 80,000 inmates, but 144,000 were being housed. So we were almost at double the capacity. So additional prisons need to be either leased or housed. The law does allow us to send our prisoners out of state to be housed. We have to pay for that at a premium, so there's a significant cost. But if we have concerns about releasing them, we should pay the other states to house our prisoners, because currently we house a lot of federal prisoners. Right. And in my book, that needs to stop. We need to look at our current concerns and what's happening in our state before we can help out the federal government and their prisoners. The only other thing is our alternative courts. Mm-hmm. And the big one that we have is drug court. Mm-hmm. Drug court allows an individual to go to rehab rather than go into jail. And that's twofold helps us. Number one, for an individual to successfully graduate from rehab, drug court, mm-hmm. That costs the state only $20,000. But to house an inmate full time for a year, that's $50,000. So if that drug court individual is successful, it saves us a lot of money. It saves us a bed in the jails. In addition, statewide, 75% of drug court graduates, those that were successfully graduated drug court, remain arrest-free for 2 years after their completion. So it kind of stops a little bit of the recidivism.
And I don't know if this is necessarily the right question to ask, but one of the things that I've been seeing is that it has introduced a lot more complexity into sentencing, as far as if you want the person to be supervised, that's kind of, I think, has been tying judges' hands a little bit, and I think there's a perception there that people are getting jail sentences and that makes it easier on them, but I think what I'm seeing, the rationale is that, well, at least they're getting post-release supervision. And do you think that's really working?
Formal supervision has the capacity to work. Formal mm-hmm. supervision is when actual physical checks are done, actually hearing that person's voice and so on. Mm-hmm. There's also informal supervision that's a lot more there's less actual contact between either the probation and parole officer and the individual, the defendant. So I believe that supervised probation and parole is a lot more effective than unsupervised.
Right.
As for sentencing, California has adopted sentencing guidelines.
Mm-hmm.
There's the low tier, the middle tier, and the high tier. And judges are supposed to start with the middle tier and evaluate certain factors like the heinousness of the crime, the defendant's past, and whether he's frequently been in court, has lots of convictions, the protection of the public, things like that.
Mm-hmm.
So the judge is supposed to start at the middle tier, and evaluating those factors, the judge can either lower the tier so the sentencing is lower, or go to the higher tier and sentence them a little bit higher. Either way, there's sentencing guidelines, and it ultimately comes out to a math problem. I've assisted judges time and time again with a worksheet to calculate credits for time served and good behavior and so on and so forth in order to properly calculate what the proper sentence is.
You obviously, maybe more than some of the other candidates, have a very firsthand view of what the issues are at the courthouse. Right down to just the physical issues. I mean, maybe that would be the first question. I mean, what's your take on what the physical needs are as far as either is it really feasible to renovate that existing structure, or what's your perspective on that?
I'm honestly not sure. I'm not an architect. I don't know how that is. Do I want either a new or rehabilitated structure? Absolutely. Mm-hmm. Do I like its current location? Yes. I love to walk down to Nevada City and eat at Lefty's or Mateo's or Fred's to have Chinese, any of those things. So do I like the convenience of being located right there with Nevada City? Absolutely. If it's determined that it's not feasible to rebuild on the same site, then I would simply defer to the architects and the people that know this and study this all the time. I'm in that courthouse all day, every day. Mm-hmm. We've had many problems. Number one, there are courtrooms, such as Department 6, that we cannot deal with any individuals in custody. So if we have a hearing with somebody that's in custody, everybody involved in that hearing has to leave Department 6, go down to Departments 1 or 2 to have that hearing, and then we go back up to Department 6 to finish the rest of the calendar. And that's simply because Department 6 does not have any of the safety protocols necessary for somebody that's currently incarcerated. So that's one issue. And it's another issue in that there's only one elevator. That means if an inmate is being moved from one floor to another, they're being on the same public elevators as the public. And that's a concern as well, and that's another reason why Department 6, which is on the 3rd floor, will not take inmates. The water in the historic side of the building you cannot drink. The water's brown. So as an individual that works there all day, every day, I definitely see the infrastructure issues. I definitely see that we need to renovate or rebuild. Again, though, I'll defer to the architects and the people that know where that should happen.
Mm-hmm. What are the other issues that you see, or the issues or challenges that you see with the court system?
Do you mean like physically with the building, or other?
No, just other issues, I guess. As far as from your perspective, do the calendars are they does that flow smoothly? Are there those kind of problems or?
In general, yes, the calendars flow smoothly. Family law is a little bit impacted. We only have one general family law department, and that comes in waves, especially in family law. At the beginning of a new school year or near Christmas, there's lots of new filings, and so the calendars get extremely heavy and people are waiting quite a bit. We also have a small bar. some attorneys, it's not as if we have 1,000 attorneys that practice and individuals are limited to only one department.
Mm-hmm.
We'll have an attorney who's scheduled to appear in both Department 3 and 5, or both Departments 1 and 3 on the exact
I've
same
seen
day.
that.
So, we are fortunate that we're small enough that the court attendants and bailiffs communicate. Has anybody seen X attorney? Is he available? Send him up when he's done. So sometimes there's a little bit of waiting with that, but that's simply because our county is small. And so occasionally there's those issues. I'm not sure how to work around those because any courtroom experience is a joint effort. We have the judge, the clerk, the court reporter, the attorneys, the litigants, the bailiffs, the court attendants, everything. All those players have to be in place simultaneously, and it's a team effort to get through that calendar that day, that morning.
Okay. Is there any question that I haven't asked that you think is something that the public should be interested in or need to know?
Relating to the courts?
Or relating to the courts, or just relating to the judicial race? Because I think I'm not sure. Obviously, I am very interested in it because I cover the courts, but I don't know if the general public necessarily cares that much who their judges, and I think they should, but
I think they should care because eventually they're going to be called either, unfortunately, in a family law case if they have a divorce or a custody issue, or in a civil case, whether it be small claims or a neighbor versus neighbor issue, or if they end up in criminal or traffic court, or simply as a juror. Eventually, everybody's going to be called to the courthouse for some reason or another. So I think they need to participate in the process. As for all of the candidates, I think we have a great panel. I think everybody has their strengths, and I can't really think of terrible things about any single candidate. And in fact, if I can remark, I will say this race has been very positive. Everybody, all 5 of us have been very encouraging to each other. We in fact had one meeting scheduled last week where all 5 candidates were supposed to attend for an interview, and due to a clerical error, one of the individuals was not invited, so only 4 of us showed up, and come to find out the 5th one hadn't even been invited or was aware of the event. And the remaining 4 of us unanimously, without hesitation, decided not to proceed that day because it simply was fundamentally unfair for that 5th person not to have the opportunity to appear. And so I'm very pleased with the panel that we have, the individuals that are running. Again, we all have our strengths for various reasons, and I'm just proud to be a part of it.
Is there anything else that you want people to know about you that I haven't covered? Or
one of the things that people say about me, especially when I serve as a pro tem judge, is that I'm very approachable. 75% of our family, civil, and probate cases, at least one side of the case does not have an attorney. So they're in pro per or a self-represented litigant. And I make sure that I take the time to give them a chance to have their say. I can't change the law, I can't change the procedures, but I can ensure that that person's voice is heard that day. And I truly enjoy doing that. I enjoy explaining what the law is and what's going on and why and what the next step is. And I think because I enjoy that, people remark that I appear approachable and like a real person. And it's simply because I enjoy it, and I hope to be doing it full time.
okay, great. Thank you very much. Appreciate it.
Thank you.